Hi everyone, I'm Vida Delisi, and in this video we're going to talk about the N12 notice versus cash for keys. What is the best option and what is the difference between either options? So often we have either frustrated landlords or realtors call me and they say, hey Vida, I'm trying to sell the property and I'm facing some challenges, or we're thinking of selling. How is the best way to go about it and what are my options? And I always give the seller landlord or the realtor these two options because it's very important that you know before you list the property how you can terminate tenancy with your tenant. Selling a tenanted property can be a challenge. We all know that. And the reason for that is because there is no interest for the tenant to accommodate the landlord in selling the property or vacate the property when the property is sold. Some of the challenges that a landlord and a realtor will face are challenges with access to the property, showing times being restricted because of COVID. People don't want other people walking into their property, touching things, or coming in without taking safety precautions. And they don't want realtors coming into the property because they know that it's going to be inevitable that they're going to have to move. So I always tell them again, Mr. Seller Landlord, you have two options. Option number one, you can list and sell the property with the tenant in there. And if the new purchaser does not want to assume the tenant, then the first option is serving the N12 notice for the new purchaser's own use. The N12 notice can only be served upon receipt of a firm agreement of purchase and sale. It's very important that the offer be firm, because otherwise, if the deal falls through and the N12 is served, it can be deemed that the N12 is served in bad faith. The N12 has certain requirements that also must be fulfilled. The first requirement is compensation equivalent to 1 month's rent must be paid to the tenant on or before the termination date as indicated in the N12. Whether or not that tenant moves out, this compensation requirement must be met. Otherwise, it is going to affect your matter at the hearing and the member will dismiss your application and you're going to have to start the process all over again. The second requirement to the N12 notice is a declaration. So in your agreement of purchase and sale, if the new purchaser wants to move in, they're going to have to declare that in their declaration, as well as in their agreement of purchase and sale. That declaration, alongside with the N12, the certificate of service, which is proof of service, must be filed by way of an L2 application with the landlord and tenant board. The board, upon receipt of the notice and application, they will then set a date for the hearing. Please keep in mind that on the second page of the N12, the third or fourth bolded box from the left down, it tells the tenant, if you don't agree with this notice, you don't have to move out. So even though this notice is a 60-day termination notice for the purchaser's own use, the tenant is not entitled to move out. Again, the tenant has no interest in the sale of the property. So if they're, for example, if they're not able to find another property, or if they're of the position that rents have skyrocketed in the area in comparison to the property that they're renting, they can wait till the hearing date and contest that notice at the board. The alternative to the N12 is cash for keys. Because remember, if a landlord seller is not able to provide vacant possession, if they agreed to that in their agreement of purchase and sale, then they're in breach of contract of the agreement of purchase and sale. And now they're going to have to pay a penalty to the new purchaser until we're able to get that tenant out. So what's the alternative? The alternative is what I call a cash for keys. And a cash for keys is exactly what I call it. It's a fun term for basically a buyout to the tenant in order for them to agree to end the tenancy. Again, this is the alternative. And I highly recommend that a cash for keys, if you, as a landlord or realtor, you're considering a cash for keys, is a cash for keys be done prior to you listing the property. The reason for that is because we want to avoid certain challenges. Challenges with if the landlord wants to stage the property, access to the property, showing restrictions, the closing date doesn't have to be compromised. If they want to close in 30 days or 3 weeks, possession of the property won't be an issue. The cash for keys needs to be facilitated by a legal representative who is familiar with the Residential Tenancies Act and the process. And I call it a process because the legal representative needs to basically pick up the phone and communicate with the tenant and see what is their position in ending the tenancy. Now, if the terms are met and all parties are satisfied, then that legal representative will draft settlement terms along with the N11 agreement to end the tenancy. The N11 and settlement terms are married to one another. And what that means is that they're signed together and filed with the board together. When they're filed with the Landlord and Tenant Board by way of an L3 application, the board will issue an ex parte order. And an ex parte order is just a fancy legal term for an order of termination of tenancy without a hearing date. So you're bypassing the amount of time it takes on an N12, which could be about 4 to 6 months, to arrive at a hearing date, and you're ending the tenancy in 30 to 60 days. Again, this is an alternative to selling the property with the tenant inside because you're trying to avoid challenges. And the biggest challenge you're trying to avoid is access to the property. I hope you learned from this video, and if you have any questions regarding ways to end the tenancy when you're trying to sell the property, call us first.